This is Protected Thoughts from the Intellectual Property Team at McBrayer. This is an overview of state or federal law and regulation and does not constitute legal advice. Services may be performed by others. For more information, visit mcbrayerfirm.com.
Welcome to Protected Thoughts. I am Mari-Elise Paul, and I am here with Bruce Paul.
Good afternoon, Mari-Elise.
We are here today to talk about Thanksgiving. It's the month of November. November is the best month.
It is. Lots of birthdays, anniversary of when we met. Thanksgiving, of course.
I like Thanksgiving. It is a holiday where we get to enjoy traditions, but also reflect on how much we have to be grateful for. Family, good health, opportunity to work together, this podcast. Haha.
There are about 3 people who are excited about that.
No, but really, Thanksgiving is a good holiday. I enjoy it. It's always a nice time to think about how much there is to be grateful for. What's your favorite holiday?
Thanksgiving for sure.
Why?
Everything that you said. Fall's my favorite season, gearing up for Christmas, but the traditional Midwestern religion is eating and football and such things, and so Thanksgiving aligns with that pretty well. Though, as I get older, Halloween is a close second.
You like dressing up in the costumes?
No, again, candy.
Yeah, I guess the decor, Thanksgiving really does get kind of the short stick of things because as soon as Halloween is over, the Christmas decorations come out, but you can still celebrate all of the good Thanksgiving things while having the Christmas decorations up and enjoying the peppermint mochas.
You trying to get an advertisement from Starbucks there?
Hey, if Starbucks wants to sponsor us, I am all ears.
So what's on the agenda today?
Well, I thought we would run through all of the ways that IP is incorporated to Thanksgiving. I bet you think there is not much IP in the Thanksgiving day, correct?
You're going to tell us differently.
It's true. Just running through all of the traditions of Thanksgiving, how's the day typically start?
Well, I have been getting up and pretending to run in a turkey trot with my son, Alex, though he's away at college. Who knows what his plans are now?
Oh, I suspect that you and Alex are going to continue that turkey trot tradition.
Shout out to the local YMCA for that.
Yes. And turkey trots are actually a tradition in lots of towns and cities in America. Our local YMCA does not have a trademark registration for turkey trot, it turns out. But there are lots of trademark registrations for turkey trots. For instance, America's Turkey Trot and Design is owned by We Run the World, LLC. Now, it does include a disclaimer of America's Turkey Trot because obviously America's Turkey Trot is descriptive. So that disclaimer piece means they get rights to the logo and America's Turkey Trot as a whole, but they cannot claim rights to just America's Turkey Trot. There's registrations for Des Moines Turkey Trot, Delco Turkey Trot, Oside Turkey Trot, San Francisco Turkey Trot. I bet that San Francisco Turkey Trot's really hilly. What do you think?
Seems pretty awful to me.
Yeah.
I don't understand. Who is We Run the World? Did you look that up? Who is this LLC?
I don't know. Didn't look it up.
Huh.
I was just fascinated by the number of registrations with Turkey Trot, but also was kind of thought that there would be more Turkey Trot registrations.
I bet We Run the World LLC owns a bunch of these probably defunct races. Be interesting to look up.
Now, running has become an increasingly popular activity. So those who are particularly motivated aren't just running a trot. What's yours, a 5K, 10K? What are you all up to now?
Just a 5K.
I thought you did a 10K. Did Alex do the 10K?
Probably so, yeah.
Yeah. Some are even running a Thanksgiving Day half marathon, like the Atlanta Track Club. So Atlanta Track Club, Inc. owns a registration for Thanksgiving Day half marathon that's registered for encouraging amateur sports and physical education by organizing, sanctioning, conducting, regulating, and governing amateur athletic programs and activities. And this registration is actually on the supplemental register, though, and they've disclaimed half marathon. So again, that means that they can't claim rights to just half marathon.
I just don't understand who's competing for the term Thanksgiving half marathon, I wonder.
Well, nobody, but since it's descriptive of what it is, you can't have a registration for it.
So I was completely wrong. We Run the World LLC has one singular registration, and it is America's Turkey Trot since 2021. Wyoming.
Wow.
Who would have known? So, half marathon. So I would run the half marathon in what, 2.5 hours. That's a pretty big commitment. It's a huge event, I know, in Atlanta. So when I come home from the Turkey Trot, you are usually making food, serving hot chocolate, and what else?
Oh, pumpkin pancakes for sure. But Emily has usually done some sort of turkey burn workout. Peloton has those turkey burn classes. What do they have? Do they have like a...
Matt Wilpers does the Atlanta Thanksgiving
he?
Day. Yeah, it's like I wonder if he has permission to do that, because he calls his run the Thanksgiving Day run or the Thanksgiving Day burn, and he always mimics it as the half marathon.
I'm sure he does. I'm sure they have all their permissions in place. But Peloton has quite an extensive turkey burn selection of classes. So they've been doing the runs, and I feel like they've added yoga and meditation and...
meditation as a burn.
I don't know. I just remember Emily coming up from the basement doing a pretty hardcore...
meditation?
No, maybe this year. But Alex Toussaint workout. And so she's definitely ready to consume some pumpkin pancakes after she has worked out. I am typically not working out. I am working on getting the turkey in the oven and watching, of course, the Macy's Thanksgiving Day Parade, which I think is one of the best parts of Thanksgiving.
It is unmissable every year for me. It's something that I love. Something back when we were able to record things, we would always record it. I know that our parents record it for Stella to watch over and over and over again. So it is a delight year in and year out.
She loves the balloons, and it makes me happy that she's now getting more interested in the theater portions and, of course, the Rockettes. Now, I didn't realize that the first Macy's Thanksgiving Day Parade was back in 1924, but it was suspended for 2 years during World War II. So the 100th anniversary parade will actually be in 2026, which would be quite fantastic to see, I think.
So does the Macy's Thanksgiving Day Parade have anything intellectual property oriented?
Of course. The Macy's Thanksgiving Day Parade is a registered trademark with Thanksgiving Day Parade disclaimed. And that registration issued way back in 1998. And the mark Macy's Thanksgiving Day Parade is registered for entertainment services, namely organizing and conducting a parade. Would it surprise you to know that companies that participate in the parade have to pay to participate? They have to pay a balloon or float fee?
Not at all. It's primetime advertising.
Yeah, that's true. I was surprised that the fee for a balloon is more expensive than the fee for a float. But then when you think about it, I guess you're paying for helium, and construction of the balloon would be pretty expensive.
I don't know. I mean, airspace may cost more, I don't know. More liability with a balloon floating away than with a float driving around on the street, I would say.
If it falls, but some of those floats are really intricate.
Yeah, they are, but they're not going to spiral out of control and land on people. I bet the balloons weigh a ton.
It's true. My favorite part of the parade is, well, can you guess?
The Rockettes.
Yes, the Rockettes. I love the Rockettes so much. I obviously, wanted to be a Rockette when I was a kid, but never quite reached the height requirement. So I always just enjoy watching them.
Literally the height, or figuratively the height of being a Rockette?
Both, I guess, but I'm not tall enough to be a Rockette. I think the height requirement now is 5'6", and I'm not close to 5'6", unfortunately. The Rockettes actually had some, years and years ago, interesting copyright infringement litigation. Did you know this?
I didn't, not until you told me.
Well, it's over the Rockette doll.
I didn't know there was a Rockette doll. Is there still a Rockette doll?
I can't remember. So I feel like when we've gone to see the Rockettes, they have dolls in the area where you can purchase souvenirs, but nothing really stands out memorable that they have these dolls. So I could totally be making that up. I'm not sure. When we go this year, we'll have to take a look at the doll to see if there are dolls, But anyway, way back in 2004, there was litigation between Mattel and Goldberger Doll Manufacturing Company and Radio City Entertainment for copyright infringement. Allegedly, the defendants made a doll that had facial features that copied those of...
Barbie, I reckon.
Yes, Barbie facial features. So on appeal, the Second Circuit held that the Barbie doll's face was copyrightable, even though the Barbie doll had just standard facial features. Barbie doll's face has a particular combination of an upturned nose, bow lips, and widely spaced eyes, and that combination was copyrightable, even though those features are standard ones for doll faces. Interestingly, the Second Circuit Court noted that it could surmise that in the highly competitive doll industry, getting the doll's face and expression exactly right was crucial to success. And Mattel apparently presented evidence that showed it frequently produced revisions and adjustments to the Barbie face in an effort to continue to appeal to young customers as their taste changed over time. So I didn't know that Mattel continued to revise a Barbie's face. I guess if you think about it and you look at vintage Barbies, they look different than the Barbies do today. But I never played with Barbies all that much. I mean, I had a couple Barbies, but I didn't play with them or analyze Barbies to know that their faces changed over time.
I certainly have nothing to contribute on this front, but I have to note, upturned nose is an attractive facial feature according to Mattel.
Well, not only Mattel apparently, but little girls everywhere that enjoy the Barbie.
I think that's speaks volumes.
The court didn't express a view as to whether the Rockette doll was copied from Barbie, but it said that because the district court erred in concluding that the defendants could freely copy the central facial features of Barbies without infringement, the district court's judgment was vacated and the grant of summary judgment, that was vacated and remanded for trial. Pretty interesting, huh?
So did they settle? Do we know what happened?
I don't know. I have to look into that.
So the Rockettes are dancers, right? Is dance protectable?
Yes. Dance is protectable through copyright as well. So to qualify for copyright registration, the choreographic work has to be fixed in a tangible medium of expression, but it has to be fixed in such a way that it reveals the movements in sufficient detail to permit the work to be performed in a consistent and uniform manner. And the Rockettes are nothing if not consistent and uniform, known for precision.
But their actual dances are not copyrightable. It's the written version of their dances, correct?
Well, the dances are copyrightable. You just have to fix them in a way. So they have to be recorded in some sort of notation. So you could do a dance notation like lava notation. You could record it through video means or textual descriptions that would enable you to reperform it the same way every time. You could take photographs, you could do drawings. Obviously, the easiest way is to record video, and then, if you're trying to reperform it in the future, you just watch the video and relearn the choreography. But short dances aren't copyrightable. Things like a touchdown dance. So, later on in the day on Thanksgiving, if you're watching football and someone does a touchdown dance, that is not copyrightable. Or like the YMCA or probably the Macarena. And neither are routines that aren't performed by humans. So for instance, like balloon choreography in the parade or machine or inanimate objects or installations or sculptures that incorporate moving parts, also not copyrightable. So think about like the floats that have movement. Sometimes they dance when the singers are singing, not copyrightable. But the Rockettes performing their kick lines and their intricate patterns where they all kick on commands, move to the beat, to the 8 count, copyrightable.
So I will have you know that one of my most beloved football stars when I was a kid was a big running back for the Cincinnati Bengals who I don't know what his mother named him, but he went by Icky Woods. He had a famous end zone dance back in the day called the Icky Shuffle.
Can you perform this Icky Shuffle so that we could see it?
No, certainly not. But I'm trying to think. I remember there was an issue over whether or not Icky Woods was able to copyright the Icky Shuffle, and I think he did. But I'd have to do some more homework. I wasn't properly prepared for this.
That is interesting. The U.S. Copyright Office circular specifically says that touchdown dances are not copyrightable. So he must have had something more than a touchdown dance.
Yeah, I don't know. I'm just doing some searching to see what I can remember or see what I can find. I do recall that Touchdown dances back in the 80s were a no-no because, old timers thought it was amateurish to do shuffles, to do dances. And the NFL hated it. Fans loved it. So the NFL folded and let him do it. It became a big issue. Here's a Washington Post article from 2022. It says fans loved the Icky Shuffle. The NFL hated it. But it would be interesting to follow up on that. Maybe we'll follow up in a future episode on that. Check our theory on this.
Yeah, look into it. It has been difficult for choreographers to enforce copyright, so it will be interesting to see what it says. You brought this to my attention, actually. Last year, the Court of Appeals for the Ninth Circuit found that it may be possible I'm not sure how to pronounce his last name.
Hinagmai, maybe?
Hinagmai v. Epic Games. The Ninth Circuit reversed and remanded a district court's decision, which had previously found that virtual animation sold as downloadable content in a Fortnite game did not infringe choreographer Kyle Hinagmai's registered copyrighted in one of his choreographic works. So Kyle Hinagami has worked with celebrities like Justin Bieber, Britney Spears, and Jennifer Lopez. So he's a famous choreographer in pop culture. He registered a 5-minute dance work with the Copyright Office. In Fortnite, players could have their avatar perform a dance that Mr. Hinagami claimed was identical to the most recognized portion of his registered work. The district court granted Epic Games' motion to dismiss for failure to state a claim on the basis that the choreography is composed of a number of individual poses not protectable when viewed in isolation, and that the overall steps copied by defendant Epic Games were only a small component of the work. The Ninth Circuit reversed. And the Ninth Circuit did note that copyright has remained a largely undefined area of law. We could do an entire podcast on my opinions about why I think choreography is an undefined area of law, but that's for another day. The Ninth Circuit adopted the Copyright Office's definition of choreography. It's the composition and arrangement of a related series of dance movements and patterns organized into a coherent whole. And they applied the extrinsic test of choreography and said the following factors should be considered along with pose: body position, body shape, body actions, transition, use of space, timing, pauses, energy, canon, motif, contrast, and repetition. In formulating this test, the Ninth Circuit emphasized that while isolated elements of a work might not be protected, the focus should be on a choreographer's selection and arrangement of the work's otherwise unprotected elements. And it was kind of analogized to the substantial similarity cases involving music and photography. And they said that the district court erred by focusing solely on the poses. What do you think, Bruce?
Honestly, I don't understand it. I don't understand anything about this. I get that the dances are creative works. I get that the dances as captured are creative works. I get that if someone creates these dances, having a video game manufacturer come out and incorporate that dance move into their game, such as Fortnite, that makes it known to the masses as the Fortnite dance. I get that that's offensive and that feels like it should be subject to a lawsuit. On the other hand, I don't know what to do with that information because, adults, kids, everyone seemed to play Fortnite there for a while. I think Fortnite still gets played quite a bit. Everyone knows that dance. Everyone thinks it's the Fortnite dance.
What's the dance?
It's like moving the arms and moving the hips. It's like back and forth. I don't know. I can't.
Do they think that's the Fortnite dance?
That's my understanding of it. That's always, when Alex and Emily were in middle school going into high school, that was the Fortnite dance. Not to be confused with the Pee Wee Herman dance or, any other thing where you're, moving your hips and moving your arms and, swaying. I'll stop talking about that. If that is a portion of a 5-minute dance, if everyone does it, is it infringing? If you compare it to, for example, YMCA is not copyrightable, apparently. Everyone knows the YMCA arm movements. Not protectable, or protectable but not actionable. I feel the same way about the Fortnite thing. If every kid is out there doing this dance.
I think the difference here is that he registered an entirety, a 5-minute piece of work. And that movement, that string that was infringed by Fortnite or Epic Games, allegedly infringed, whatever you want to say, was a portion of the work that was registered. So it's not like what was initially choreographed was just this hip movement. It was the most recognizable piece of a larger work. So in the claim, and what he objected to was what was taken by Epic Games was the most recognized piece of this work and put in the game. So think about all of the pop culture dances, and because of TikTok, like all of the TikTok dances. So choreographers come up with however long movement to fill the entirety of the dance for the singers to perform. But there's 8 count, 16 count, 32 count that really catches on, and then everybody knows what that is, and then they start doing that, and it's catchy. I can't think of a good example off the top of my head. But that's what was copied and taken. And so what's interesting is that the Ninth Circuit also dismissed the idea that the copied portion of the copyrighted work was short and noted that the short does not always equate to simple. So I was a dance major in college, and I 100% agree with the idea that short does not always equate to simple. There can be a lot of layers in a short 8 count or 16 or 32 count that make it complicated and involve a lot of artistry in it and should therefore be protectable.
Again, I'm not disputing that the 5-minute choreographed dance isn't protectable. And I'm not suggesting that this person had no right to be miffed at Epic Games or whoever else. I think in terms of like fair use. The Copyright Act has Section 107 are the fair use factors. And one of the fair use factors is amount and substantiality of the portion used. So if we were talking about a movie, and we're watching a movie, and as we're watching a movie, the movie is on a TV in the movie we're watching. So you're watching a little snippet, like if there's a 2-hour movie, say we're watching Home Alone. And in Home Alone, they're watching It's a Wonderful Life. Well, there's like a 2-minute segment of the people in that room watching It's a Wonderful Life. You really only see a second or 2 or 3 or 4 or 5 or maybe even a minute of It's a Wonderful Life. That is 1 minute out of a 2-hour movie, not a substantial portion, probably fair use, especially when you consider the rest of the other factors. If we're talking about a 5-minute dance act or dance choreography, I don't know the proper terminology here. I apologize. And someone removes this simple dance, moving the hips this way, moving the hips this way, moving the arms this way, moving the arms that way. I just said and performed the entirety of that Fortnite portion of the dance, which is a second and a half. It just feels like there's not a lot there to sink your teeth into. That's my thing that I don't quite understand. I don't understand how that's not, you're taking a movement that perhaps is from a choreographed dance, perhaps introducing it into a video game, which is obviously in and of itself its own copyrightable work. It makes up a portion of that video or of that video of that game. I just don't understand how it's actionable, that's all.
Flossing is the term.
Flossing is the dance move?
Yes.
Yeah.
I think, again, this goes back to the concept of short does not necessarily mean simple, and you have to look at not just the length, but with dance, you're looking at all of the different layers. So timing and body movement, position, shape, all of the things that are layered on top of just one pose. And you compared it earlier when we were talking about music. You analogized it to, well, is it like the chord progression in a song, or is it like if somebody copies the most recognizable, it may be only a few 8 counts of a song, but the most recognizable chorus of a song, then that is more damaging, or I don't know what the proper term is here, but more recognizable, I guess, than it would be if it were a different portion of the work that were copied.
Yeah, maybe so. Or, I could talk myself out of it. I could say, the only thing I know about Fortnite is there are however many characters, and each one of them does their own dance. And so maybe that one character's dance that one character does is such a significant part of Fortnite that it's not fair use. That's also possible too, I suppose.
Well, and why can't he just come up with his own dance? Or why can't he or pay the choreographer? Why does he get to borrow choreography from a well-known dance?
Yeah, well, I don't know. I mean, it looks like they settled the case. It's entirely possible that it could have gone to a jury and they could have found no infringement at all. So we're sort of putting the cart before the horse in terms of our assessment of this. I mean, this was an appeal to the Ninth Circuit. The Ninth Circuit sent it back and said that it is a protectable thing, and then the parties settled. So we never got to find out what a jury found on it. This is just us sort of hypothesizing about what we're thinking.
Which is the fun part, right? I mean, as you said earlier, or I said, the body of law as it relates to choreographers, undeveloped, and this is a piece that's developing further. Bringing it back to the Rockettes. The Rockettes' work are protected by copyright, and who knows about how enforceability would go. Like a kick is a kick, but we see kick lines all the time. So kicking and turning.
I mean, I'm thinking of, again, going back to my formative years. You had hip hop dancing, you had the Running Man, all of these dances. They probably were initially part of some choreographed dance that everyone picked up on. I'd be curious to know now. I don't know.
Oh, you're taking me back to my dance history days.
Yes. You got credit for that?
I loved it. Oh, yes. Loved dance history classes. All right. Well, looking forward to seeing the Rockettes on the Macy's Day Parade. And the dancing is not all that's protected by copyright. All of those Broadway performances are. Are those your favorite part of the Macy's Day Parade?
I'm an aspirational theater goer, so I always like to see what the new shows coming out are, and they always are a preview. What's good, what's on Broadway.
I really always enjoy the singing and dancing, the classic ones. I've always loved the Fosse-based theater. What's your type of favorite show? Anything, right?
Yeah, I like live performances of any kind, so I don't have a particular favorite. I suppose what caught me on to all of it was, Rent was the first loud one that I loved. But yeah, all that stuff, it's all good.
Well, all of those portions of the parade are also protected by copyright. There's licensing deals that have to be solidified between the record labels and the choreographers and the production companies and theaters. And NBC obviously has broadcast rights for the parade, and they are the production company that gets to televise all of the content appearing in the parade.
So moving on to post-parade activities, everyone has their Thanksgiving recipes. Not copyrightable. Though, and the premise there is that although fixed ideas on a medium are protectable by copyright, there has to be some creative notion to them. So in copyright, you will frequently hear that facts are not copyrightable. So a list of items that together comprise your favorite dish are not copyrightable. Frequently, this comes up in photography. So photography of dishes is not necessarily copyrightable, because if you're just taking a picture of food, it's just a fact of the food. Now, obviously, photographs of food are quite popular and a pretty booming business. Lots of books of food, lots of books of photography of food and such.
So are you suggesting that the image of the actual food is not protectable, but the book would be protectable?
It's my understanding. I mean, I think that if you create a beautiful, it's this idea of, if I have a piece of meat on my plate and I take a picture of the piece of meat on the plate, there's not a lot creative about that. But if you're taking a picture that has different lighting, different angles, different presentation aspects of it, then that gets you into the creative. Now, the reality is, when you're filing a copyright registration, is anyone actually going to look at this and make that decision and say no or yes?
Maybe.
Maybe. But if you're doing a group registration of 250 photographs, probably not.
You gotta have Bruce Paul on the other side to challenge it, I guess.
But Obviously, recipe books can be copyrightable. Books that organize different recipes, books of favorite foods, of classic dishes that are organized, that select the different dishes to be included in the book. Those books are copyrightable, as are obviously the web pages that contain the same information. But the ingredients, the lists within the recipes themselves are not individually copyrightable.
There's an interesting Seventh Circuit case, Publications Inc. Limited v. Meredith Corp., that talks about how certain recipes may be copyrightable if they convey more than simple directions for producing a certain risk. So they have to be accompanied by substantial literary expression. And I think that's why you see all of the bloggers and the foodies that contain so much content about why they like a particular recipe before you get to that little jump to recipe button. And like you said, in the recipe books, the cookbooks, if there's all of the extra content beyond just the recipe and the simple instructions for how to cook the recipe, that is all copyrightable.
I think we have a recipe book on our shelf that's called Thug Kitchen. And I'm always, when I think about this, I think about it in that terms. It's if it's a list of adding this versus that, then it's not really protectable. But in a book like Thug Kitchen or any of these other colorful books that add character and obviously slang and
personality,
coarse language and to the recipe and to the cooking process that clearly are created to make people smile and laugh and purchase the book, then certainly I think that's the type of circumstance you're talking about, where there's extra content to the ingredients.
Yeah. I think a lot of our cookbooks actually have those, like, author, those famous chef cookbooks that we have all have their own flavor. There was actually a New York Times article on this topic last year. It talked about, do you remember that article? I think you read it too. It talked about how cookbook authors, bakers, cooks more often took the online approach to airing their grievances of how stealing recipes was truly an ethical issue, because there wasn't really much they could do about people misappropriating their recipes, since recipes are fact-based and not copyrightable, but it is a frowned upon ethical issue to just share or steal recipes. So I guess the best way to protect my coveted Thanksgiving recipes is to keep them trade secret and not share them.
So after the turkey trot, after the cooking and the parade and the dining and watching some football, go to sleep, and then Black Friday begins, Cyber Monday, and let the trademark infringement commence, right?
Is there a day of the year that you can think of where more online trademark infringement occurs?
Certainly not many where there are the allegations of it, and I think it's always been out there, but Google AdWords has really driven it, because as anyone who uses e-commerce platforms, or everything is Google owns all marketing, it seems, online marketing. Everyone goes through Google AdWords, and anyone can purchase AdWords of any brand. Now, you can't purchase AdWords of your competitor and then use those AdWords in a confusingly similar manner to your product.
And Google AdWords policy even says that. They say the advertising policy is a section on abiding by trademark laws and protecting the rights of trademark owners. The policy explicitly states it doesn't allow ads that infringe trademark rights, but
it's entirely probable that if I Google, for Alex, the Nike Book One basketball shoes, I'm going to see on cloud advertising, I'm going to see Adidas, I'm going to see Under Armour, I'm going to see all of the competitors, because all of the competitors understand that Nike is Nike, and Book One and all of those marks and brands are the hot things, and they want to be considered right up with them. Now, they're allowed to do that, of course.
And the problem comes in when?
If Adidas, for example, purchases a Google AdWord of Nike, and then puts like the Nike name or Nike logo as a hyperlink, and you click on that Nike logo or that Nike name and it leads you to the Adidas website, that's where you get in trouble. It's where the landing page is misdirected from a false use of someone else's name or mark.
Right. Or the Nike or someone else's trademark also appears in the ad copy.
Right. On the other hand, there's a lot of case law that talks about the idea that if I'm searching for Nike and Adidas comes up and Adidas is clearly marked and Adidas is above Nike and I know that I'm clicking on Adidas, the case law is now suggesting that people are pretty sophisticated users of the internet. They know what they're clicking. They may have thought that they were searching for Nike, but when they clicked on Adidas, they knew they weren't clicking for Nike. And so that is more often than not fair game now. Now, in these cases, the devil's in the detail. I mean, the ads can be tricky. The landing pages can be tricky. There's always cleverness afoot on these things, but it's a rampant season for trademark infringement.
Yeah, we also see it in the form of domain name infringement. We see fraudulent sites popping up. So duplicative sites will pop up where fraud actors will register a domain name of a brand owner with just one letter off, hoping to get consumers that way. And so obviously it's like playing whack-a-mole with those bad actors so that consumers aren't purchasing from the fraudulent site. But
many of the online commerce sites, they will accept complaints about it. So if you are a brand owner and you see this going on Amazon or through Google, the Google AdWords platform or any of those things, you can take action by notifying the platforms, and the platforms may or may not take action. But there is that outlet for providing notice.
So it's a busy and exciting Thanksgiving season coming up.
Well, I think that's all. I think that's all we have. We've gone plenty long enough.
Remember, we are lawyers, but we are not your lawyers. We just love talking about the law. Have a very happy Thanksgiving.
And we will talk to you next month, probably about some Christmas issues, some more holiday issues in the law. And then at the beginning of next year, we have Public Domain Day, which is when things that are protected by the copyright become public domain. And that'll be exciting for us. Have a happy Thanksgiving.
Happy Thanksgiving.
All content copyright 2024 McBrayer PLLC. All rights reserved.